Yes, Jeff, thank you.
Okay, thank you.
Ooh. All right, Chair, we have everybody present. Lobby is open and the recording has started.
Great, thank you, Dustin. Good morning, everybody. I will call to order the July 21st, 2021 meeting of the Washington State Liquid Cannabis Board. I'm David Postman, the board chair. I'm joined by members Ollie Garrett and Russ Hauge. I'll ask everybody to mute until it's their time to talk. First thing up is approval of meeting minutes, both of the June 9th, 2021 board meeting and the June 23rd, 2021 board meeting. Is there a motion for approval?
This is Ollie. I move approval of the June 9th, 2021 board meeting and approval of the June 23rd board meeting minutes.
And this is Russ Hauge. I will second.
And those are approved. Thank you. We're going to postpone consideration of the July 7th, 2021 board meetings. Those were the really long one from the other day, and we're still getting that ready to go. So we'll put that off to our next board meeting. Next up is alcohol-related rulemaking timelines, and turn it over to Audrey Vasek, the Policy and Rules Coordinator on the alcohol side.
Thank you, and good morning, Chair Postman, board members Garrett and Hauge. I have a few brief updates today on the alcohol rulemaking timelines, the same ones I gave during caucus yesterday, but I'll go again for the benefit of the public listening today. So for my first update, for the rule project to implement 2021 legislation and grow second substitute House Bill 1480 related to the COVID-19 alcohol allowances, the internal rule drafting work group has met a total of 9 times so far to develop conceptual draft rules. We've completed initial rule drafting work for the 3 endorsements created by House Bill 1480 for the delivery of manufacturer sealed alcohol products, cocktails and wine by the glass, and growlers for curbside takeout or delivery. We plan to hold a listen and learn session on the conceptual draft rules for these endorsements on August 5th from 1 to 4 p.m. And Gov Delivery messaging on how to join the virtual listen and learn forum is scheduled to go out later this week. The internal rule drafting work group is still working on developing rules for outdoor alcohol service areas and food service requirements. Our target is to complete those in August, and we'll hold a second listen and learn session once those draft conceptual rules are complete. I anticipate preparing a CR 102 package for the board to consider in late September. Next, for the rule project to create summary suspension and stay provisions to enforce governor's proclamations, the emergency rules related to this rule project expired as scheduled last Thursday, July 15th. I've scheduled internal meetings with staff and board members this week to discuss options for next steps with the permanent rulemaking project, including whether to withdraw or revise that CR 101. If the decision is to withdraw or revise, I could prepare that for presentation to the board at the next meeting on August 4th. I also have an update today on a rule project that has been delayed for some time related to alternating proprietorships for distilleries and craft distilleries. For background, this project was initiated by filing a CR 101 in November of 2019, but has been delayed since October of 2020 to allow time to complete the other distillery-related rulemaking projects with potential overlap. That was in the project to implement and grow second substitute Senate Bill 5549 from the 2020 session, as well as the distillery reporting and payment or Blue Spirits rule projects. So now that those other projects are complete, we're revisiting this alternating proprietorships project, and I've scheduled internal meetings this week to discuss options for next steps. So that concludes my updates for today, and if there's any questions, I'm happy to answer them.
I have one for you. And the last thing, can you give me the brief description of alternating proprietorships? Is that what you said?
Correct, alternating proprietorships. So
what
when
does that mean?
right, when two entities, so it could be, in this case, it's for distilleries, want to use the same manufacturing space, but share that like equipment and use it at different times.
I see. Okay, got it. Thank you. Appreciate that. I don't see any other questions for you, Ms. Vasek. Thank you.
Thank you very much.
And we will move to the cannabis side of the house. And Kathy Hoffman, the Policy and Rules Manager, and Jeff Kildall, the Policy and Rules Coordinator, will take this part. Ms. Hoffman, is that you first?
Yes, it is, Chair Postman. Good morning, and good morning to board members Garrett and Hauge. I'll provide a brief update on our evaluation of THC compounds rule project, and Jeff will take up the rest. We held our second deliberative dialogue session on cannabis plant chemistry yesterday, and at peak we hosted 132 participants. The session was designed to help us drill down further on understanding cannabinoids based on scientific fact and empirical evidence. It also helped with our understanding of the differences between botanic, synthetic, and artificial cannabinoids and how we might articulate those differences in regulation. I would again like to publicly thank our panelists for the gift of their time to this effort. That includes Dr. Nefi Stella from UW, Dr. David Gang, from WSU, Dr. Brad Douglas from the workshop, and Jessica Tanani of Verde Bio, and that's an agricultural biosciences company. So based on the richness of the panel dialogues and the information we've culled from them, I anticipate having a set of draft conceptual rules ready for release towards the end of August, if not sooner. This aligns us for a listen and learn session in early September and keeps us on a revised timeline, a CR 102 presentation in late September and a hearing in November. So that's the extension of my portion for rule updates today. Any questions that I can answer?
Seeing none, we will move to Jeff Kildall then. Thank you.
Thank you.
Thank you and good morning, Chair Postman and board members Garrett and Hauge. Here is a brief update on cannabis rules in progress today. Starting with the cannabis quality control rules and consistent with our last update, we now have completed 4 internal rule drafting sessions, and we have one more session scheduled this week to continue work on the cannabis quality control rule redesign. We received only one bid concerning our request for an economist to help with drafting an updated small business economic impact statement, and we met with Oriya on July 8th to review the bid. We have finalized details of the contract with the vendor, and we received the final bid yesterday, and will review this bid this week. With respect to criminal history background check redesign, we received a small amount of feedback on the draft conceptual rules shared, but no comments have been received to date on the CR 102 we brought to you for approval on July 7th. As a reminder, the public hearing on the proposed rules is scheduled for August 18th. And with respect to the permanent rules referencing the State Board of Health, or SBOH, vitamin E acetate prohibition, I will present the CR 103 rule package to you during the next agenda item. This concludes my update for today. May I answer any questions?
Don't see any, so why don't we move to the next item on the adoption of the 103.
Right. Thank you, Chair Postman. This morning, I would like to present to you for your approval the CR 101, CR 103 to adopt the permanent rules that include permanent cross-references in our cannabis processor and retailer rules to the State Board of Health permanent prohibition of vitamin E acetate. By way of background, the LCB prohibited use of vitamin E acetate by any person licensed under Chapter 6950 RCW or the Controlled Substance Act by emergency rule last September. The LCB prohibition applied to cannabis processors and retailers, and emergency amendments were added to WAC 314, 55, 077, and 079 that would allow the board to take disciplinary action if a licensee failed to comply with the LCB prohibition. At the same time, the Washington State Board of Health was working on a permanent prohibition of vitamin E acetate that would also apply to any person licensed under the Controlled Substances Act. That rule became permanent last November. As a result, and as intended when we began emergency rulemaking, The proposal makes permanent reference in WAC 314-55-077 and 079 to the permanent State Board of Health vitamin E acetate prohibition. If these rules are adopted today, the LCB prohibition can be rescinded and the emergency rules currently in effect will be allowed to expire. For a brief procedural history of this particular rulemaking, we filed a CR 101 for this project on March 31st, 2021. The CR 102 was approved and filed on May 26th, 2021, and the public hearing on these rules was held on July 7th, 2021. No comments have been received on these rules, and the rules before you today for approval have not changed since the original proposal. If approved today for filing, the rules would become effective 31 days from today on August 21st, 2021. I would ask for your approval to file this CR 103 today. Thank you, and may I answer any questions?
Great. Any questions? And if not, is there a motion for approval of for board adoption of the CR 103 for enforcement of the State Board of Health prohibition on vitamin E acetate?
This is Russ Hauge. I have no questions and I move approval.
This is Ali, and I second.
Okay, great. Well, then that is approved. Thanks, Mr. Kildall.
Thank you, Chair.
Good to see that one across the line. Appreciate that. We now move to general public comment. A couple of reminders. One, everything, this meeting is recorded. It'll be available sometime this afternoon, probably on our website. After I call your name, please state your name and affiliation. And be mindful of your time. You have 4 minutes. When you have 30 seconds left, Dustin will politely interrupt and remind you that you have 30 seconds. And it'll take us for 1 second to enable your audio and video. So just thanks for your patience on that. We have 2 people signed up at this point. The first is Micah Sherman.
Hi there, can you hear me?
I can, yes.
Hi, this is Micah Sherman. I'm one of the owners of Raven. We're a tier 2 producer processor here in the Olympia area. I'm happy to be here, and thanks for giving me the opportunity to address you. Firstly, I just wanted to start out and say that I got a chance to attend the deliberative dialogue yesterday that Kathy coordinated, and I just wanted to thank her and the agency for putting that on. I thought that was a very informative event and really clarified the situation on all of the matters related to that. So I really appreciated that happening and look forward to seeing, I'm sure, continued great work from Kathy and her team on that rule project. The other reason I wanted to talk today is in my role as one of the board members of the Washington Sun Growers Industry Association, in the process of becoming the Washington Sun and Craft Growers Association. I just wanted to remind the board and the public that the cannabis industry is still in need of quite a bit of updates in rule and law to make sure that we're all operating in an environment that is going to be able to produce equitable results for everybody in the cannabis supply chain. And just to remind you that the 2021 has been a very difficult year for a lot of farmers and continues to be a very difficult year for a lot of farmers. And we really do need to start having some forward-thinking conversations about how do we solve that dynamic and how do we bring relief to farmers throughout the state. And in the past, we've discussed trying to coordinate with the board to allow some farmers markets in cooperation with existing retail stores and other creative solutions to get different paths to market for small farmers. And I want to continue to ask that sort of work get talked about and continue to be discussed and find avenues for us to solve the issue of what's going on for farmers, because we're losing a lot more people. A lot of people can't afford to plant their fields. A lot of people are, struggling to get by, and a big reason that's happening is because we've got some structural issues that are built into the marketplace that are not going to go away unless we address them. So by continuing to have things move forward in the same structure that they are, we're selecting outcomes for the industry that I don't think was the intention of the original initiative, and I don't think it's been the intention of laws that have been passed by the legislature since then that have really tried to focus on equity and inclusion. And I don't think that we're taking active steps to move in that direction. And I'd really like to encourage us all to think about how do we embrace the spirit of those bills that were passed for equity in the cannabis industry, while the work of the social equity task force continues. And what can we do in the interim to make sure that when that work is complete, we have an industry that can support successful farmers, because we're going to be needed for all of that to be successful. Thank you.
Great, thank you. Next on the list is Jim McRae.
Oh, can you hear me?
I can, yes.
Can you see me?
No.
Oh, now can you see me?
Yes, there we are.
Wonderful.
Yes.
Okay,
Good morning.
first time. Good morning. Okay, thank you. I wanted to quickly, a couple of things. Just a recognition of one of the larger successes of the agency over the past 7 years, and that really is driving a new source of revenue for the state, incrementing the overall revenue generated by the agency and contributing to the operations of our governance. So thank you for that. I think that has been done certainly above the expectations of the EFRC and other bodies. Frankly, it falls well below the expectations that I set for the market and my expectations of what the potential of this market is, if indeed the regulated portion of the cannabis market in this state is able to capture the majority, if not the vast majority of consumers, which I don't think has been the case when you weight it for consumption on a consumer basis. So that has been well done by internal standards. I think it could be improved dramatically. The two areas where I do believe it could be improved most readily and most rapidly, and in a manner that is most effective for the positive good of the state and the realization of the mission and goals of the agency, is to do a better job of ensuring that the products that are moving in the regulated market are actually, consumers can have a reasonable expectation of safety in doing them. Right now, that is simply not the case for a number of reasons. I'm not going to repeat myself on why. I think you're aware of that. Some of them are emerging now, which are really confusing, and I commend you for your efforts to try to deal with those emerging potential threats. The second one is the medical aspect of cannabis. We had a very functioning Green Cross system. It was well functioning for the people who actually used it for medicine. It was clearly abused by many. The move to regulation has effectively killed the service that entity once supplied to the state. We had a great model. We had something that served people's needs. It had providers out there. We had the genetic diversity. We had a lot of craft producers, small mom and pop shops. All of them virtually were illegal at the time. Some were accepted by the state, but illegal. That's largely gone. It's underground. It's still servicing the needs of many people, but those people are all still criminals. And I think that's just a shame here, 7+ years into legalization, or post-prohibition, as I prefer to call it. My focus going forward it's been on the commercial side of this business, but it really is going to be about consumer protection and trying to revive some functioning medical attributes in this state under the regulated system. You have so much work to go there. A couple of things along those lines. One is when corruption is actually pointed out in the agency and when it has an evidentiary base, I really do hope that you will act, not only on things that you may have heard to date, but on the things that will be revealed in the not too distant future. Secondly, the notion of equitable treatment is not just a race-based thing. This agency, just as an editorial observation, has basically acted in a discriminatory, negative discriminatory fashion towards cannabis relative to how it has regulated tobacco and alcohol for much of the last 7 years. It's blatantly obvious in some cases. In others, it is, I recognize. Thank you, Dustin. I recognize that it's simply the constraints on the agency, but it is a theme that runs through so much of what you have done and so many of the very poor decisions that have been made and have been perseverated upon. So to that end, I would want one last thing. When you go into attorney-client privilege situations, please remember one thing. I do recognize the reality of your agency. The Attorney General is the attorney of the people of the state of Washington. And the notion of attorney-client privilege in your operations, when litigation notwithstanding, is somewhat offensive to me. Thank you very much. I appreciate all that you do. Best of luck going forward.
Great, thank you. Appreciate that. That is the last time. Dustin, let me just double check. Did you get any late signups for general public comment?
No, Chair, we've got everybody covered.
Okay, great. Then that brings us to adjournment unless Member Hauge or Garrett have anything to add before we adjourn. Seeing none. Okay, great. With that, then we will adjourn the Wednesday, July 21st meeting. And thank you all for participating today. And we will see you the next time around. Have a good day.